They've taken away my constitutional rights to speak, and that includes speaking to you. I have a lot to say to you, and I'm not allowed to say it. And I'm the only one. Everyone else can say whatever they want about me. They can say anything they want. They can continue to make up lies and everything else. They lie.
Former President Trump lashing out against the gag order placed on him in the New York hush money trial. It is time now for our legal panel. George Washington University law professor and Fox News contributor Jonathan Turley and former Principal Deputy Assistant Attorney General Tom Dupree. Welcome back, gentlemen.
Thank you.
Thanks, Shannon.
Okay, so we're into the hush money trial. We think arguments will start up tomorrow. Now, there's this back and forth, too, about the fact that the defense says they don't know who the witnesses are going to be. And the Washington Post reporting on this said the two sides had sparred Thursday over the issue, with prosecutors saying they would not provide witness names in advance because of Trump's repeated violations of a gag order barring him from talking about witnesses in the case. We have a look at some of the potential witnesses who could show up. But, Jonathan, how do you prep for day one if you don't know who might be on the witness stand?
Right. This has been a problem with criminal defense attorneys like myself. This is a standard problem of prosecutors holding on to the last minute to make disclosures. What concerns me about this is the judge's response. The judge should have said you should err on the side of disclosure. And also should point out whatever sanctions there are for the gag order, those will come at my judgment after we have a hearing. This is not on the menu of options for you. You can't restrict the fairness of the trial or disclosures of witnesses because you think he violated an order. That's up to me. I think the court could have done that. And this is one of those times where I feel like the judge could have done more. There's no reason to do this, in my view, but it really works against due process and a fair trial. You want the parties to be prepared. And here you've got the district attorney saying, I'm just going to unilaterally withhold them because I think there's a violation here.
Mm-hmm. So what jurors will get to is, we think, witnesses who we don't know starting tomorrow, potentially, we're at least opening arguments. But we're told about the jury that's been seated is it includes, quote, multiple lawyers. Politico says Trump's legal team might see a silver lining in having lawyers on the jury. Quote, they're not emotional thinkers. This one trial consultant says the profession requires them to do analysis, and emotional thinkers get more easily swayed by the side that goes first, the side that tells a good story. Tom, is it a plus or minus that he's got some lawyers on the
I think it is a plus for Trump that there are lawyers on the jury, and here's why. Prosecutors notoriously don't like seating lawyers on juries precisely because they are independent thinkers who often think they know better than the prosecutors do. They can be a bit of a wild card. They come to jury service with a lot of legal education, and you never know what goes on in the jury room. And look, having chosen juries, having tried cases in front of juries, lawyers are going to spend the next 6 weeks trying to read the tea leaves, watching the jurors' reactions to the witness testimony as it comes in. But no one is ever going to know what those jurors are truly thinking until it's time to deliberate and render a verdict. But the fact that there will be lawyers participating in deliberations and rendering the verdict, definitely a plus for the defense.
This is one of the few times where Tom and I disagree because I have long opposed lawyers even being allowed to be on juries. On this case, it could be highly damaging because many of us are still debating what this indictment means. We're not convinced or we're not certain what the crime is that was the motivation of the alleged, what was a misdemeanor under state law. To have lawyers in there, they can be given undue influence with a jury. And if they say, oh, no, this is clear, this is standard, that may sway them. That's why in some states like Illinois, they used to say if you had even more than 1 year of law school, you wouldn't be on a jury. I think it's not a good thing for a defendant because of the influence that can be exercised over the jury.
I feel like it's gotten me out of jury duty many times. That and being a member of the media. Okay, so let's talk about the other case that isn't getting as much attention, could be very critical to the federal cases, which is the Supreme Court on Thursday has added this expedited argument about immunity, about whether President Trump has immunity. The Atlantic says if that's granted, they call it one of the most dangerous assertions. They say a president would have license to do things like use the U.S. military to subvert democracy, for example, by endeavoring to remain in power past the end of his legitimate term or avoiding accountability, and the country would have little to no recourse, Tom.
Yeah, look, this case may not be getting the attention that a big courtroom drama in New York City does, but you're absolutely right. It is a critical case for, frankly, the future of our republic. book about how much presidents can do in office without potentially being subject to criminal jeopardy. This is a question the Supreme Court, somewhat surprisingly, has not yet definitively resolved in our nation's history. I think they are going to be wrestling with thorny questions. The SEAL Team 6 example. Could you have a president order a political assassination? They need to give presidents some degree of protection. I'm not sure they are going to go the full route of granting absolute immunity, carte blanche to any president, but they may say that the district court's interpretation of immunity was too narrow, too crabbed, and possibly send it back for the district court to make a closer examination of whether President Trump should be immune from some of these charges.
And then that drags this thing out even further if they do send it back to the trial court. Well, in one of his all caps postings, as he likes to do, President Trump on social media says this: if immunity is not granted to a president, every president that leaves office will be immediately indicted by the opposing party. Without complete immunity, a president of the United States would not be able to properly function. How does that land with the justices?
Well, everything is contextual at these moments. And I think these Democratic district attorneys have really made the case for Trump. They've shown how presidents can be taken from pillar to post across the country, being hit civilly and criminally with these types of charges. And they've made the case for the need of some protection. It's doubtful, and I agree with Tom, that they're going to go all the way that the president went in terms of the absolute claims of immunity. But the president will win significantly if they send this back. That is, the court could simply say, look, we think you went too far. You didn't give us a record and create a more nuanced approach. Right. That will throw a wrench into the plans to hold the trial in D.C. with the special counsel. And I think that there's dangers on both sides. And I think that some of these justices will be as concerned with the sweeping quality of the district court opinion as they are with the claims of the former president.
All right. I'll see you there Thursday, at least in spirit. If you're not there in person, I'll be there. Jonathan and Tom, thank you very much. Always appreciate your time.